Hello, everyone, and welcome to another episode of Legal Tech Corner. Today, we are going to continue talking about capacity. This is the second part, and as always, we will firstly concentrate on the legal part of the topic, and then we will go through the legal tech perspective of the same view. So, let's now discuss the second category for limited capacity. We have in the second category the mentally incapacitated individuals. These are the persons who lack capacity because of any disturbance or impairment of their mind or brain, and this has a permanent or temporary effect. Important is that at the point of forming the contract, they lack the decision making ability. They are not able to make decision on their own. And this kind of agreements are in the beginning valid. However, there they can be voidable based on the petition of the mentally incapacitated individual. Important is here to prove that firstly that the incapacitated individual was not able to understand the whole nature of the agreement. And as the second point, they need to provide evidence that the other party of the contract was aware that they did have limited capacity and were mentally incapacitated. So these 2 points are established in the case law in the case of the Imperial Loan versus Stone. Now the question is whether these types of agreements can be fixed, can be rectified by the court. The short answer is yes, and this was established in the case of Hart versus Connor. And it says that the contract can be adjusted and made enforceable, even if initially it was not enforceable. But these adjustments made the contract fair, and it is now properly formed. So the adjustments should make the contract fair afterwards. It should not initially be fair, but after the changes that are done in the contract, they become proper and acceptable for the both parties. Now let's understand what is the similar situation for the corporations where they have limited capacity. In fact, corporations by default are limited based on the conferred or granted powers by their articles of associations. The article of association provide limited powers for the directors, what they can do and what they are not allowed to do on behalf of the company. And this was established in the case of Ashbury Railway Carriage versus Reach. But what happens if the company still goes beyond their powers, which was granted by the Articles of Association? In this case, the contract is considered ultra vires, which directly translated means beyond powers. And the contract is from the very beginning void. However, there are some exceptions in case of there is a trust from the third party. They believe that they were acting in good faith. Namely, they believe that the director who was representing the company and entering into agreement on behalf of the company had the authority to do so. And if they believe that they had this authority, then the contract won't be void. This is the main perspective from the legal part on all the 4 categories that we have discussed initially. Now let's try to understand how legal tech can impact on one of these categories or automate in some way the processes that we have discussed. So a legal tech tool can do an automated behavioral check on the actions of the user. We can have of we can think of slow typing, for example, or repeated mistakes, or any distractions or hesitations from the side of the user. This can be easily tracked by the tool, and we're not limiting directly at this point, but the tool can suggest some additional tests in form of mini games or memory checks, which will additionally validate the potential capacity of the user who's trying to enter into binding agreement. And these live checks may provide some results which afterwards can evaluate the level of capacity in theory. But if there are any hesitations from the side of the tool, it can forward the this case to a human reviewer, which will eventually evaluate this person and their capacity. This is one example on how automation can impact capacity. Thank you very much for watching, and see you in the next episode.